this episode, we examine 3 separate probable cause hearings held before Judge David Fletcher of the Harris County Criminal Court in Houston, Texas. A probable cause hearing occurs shortly after an arrest, particularly when the arrest was made without a warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, an arrested individual must be brought before a judge without unnecessary delay. During this appearance, the judge advises the defendant of their rights and evaluates the facts presented by law enforcement to determine whether probable cause existed for the arrest. If the judge concludes that probable cause was lacking, the defendant must be released. Our first hearing involves defendant Raquel Rodriguez, who was charged with driving while intoxicated on October 28, 2024. Her probable cause hearing was held on November 4, 2024.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking, and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat.
Judge Fleer found no probable cause for the charge, concluding that the officers lacked sufficient indicia of intoxication to justify conducting standardized field sobriety tests, or SFSTs. Because SFSTs prolong a traffic stop and create a more extended investigative detention, officers must have reasonable suspicion that a driver is committing an intoxication-related offense before requiring these tests. In this case, the only evidence presented was the odor of alcohol and Ms. Rodriguez's statement that she had consumed 2 drinks, the last of which she said was finished 2 hours before driving. Relying on state and federal case law,
along with Article 38.23 of the Texas Code of Criminal Procedure. Judge Fleer determined that this evidence did not establish reasonable suspicion to extend the stop for field sobriety testing. Under Article 38.23, any evidence obtained as a result of a constitutional violation, such as prolonging a traffic stop without reasonable suspicion, must be excluded from use against the accused. Because the SFST results were inadmissible, Judge Fleer concluded there was no probable cause for the arrest. The state later dismissed the charge on February 24, 2025. The next probable cause hearing we examine also took place on November 4, 2024. In that case, defendant Keon Shaw faced a charge filed on October 28, 2024, for fleeing a police officer in violation of Section 545.421 of the Texas Transportation Code, which makes it a misdemeanor to willfully fail or refuse to bring a vehicle to a stop after receiving a visual or audible signal from a pursuing police officer.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man, good luck.
Judge Fleer found no probable cause because the state failed to present any specific allegation regarding the driver's speed, information necessary to justify the initial traffic stop. Although the Texas Transportation Code does not explicitly require the underlying stop to be lawful in order to charge someone with fleeing, the Constitution still governs police conduct. As discussed earlier in this episode, Article 38.23 of the Texas Code of Criminal Procedure mandates that if a stop violates the Fourth Amendment or Texas law, any evidence obtained as a result including the officer's account of the driver failing to stop, must be excluded from court. Under the Fourth Amendment, an officer may not detain a vehicle without reasonable suspicion supported by specific, articulable facts indicating that a traffic offense or other crime has occurred. In the 2005 case Ford v. State, the Texas Court of Criminal Appeals held that an officer's conclusionary claim that a driver was following another vehicle too closely was insufficient because the officer failed to describe the actual distance between the vehicles. The court emphasized that bare conclusions without factual detail cannot establish reasonable suspicion. Applying that reasoning, Judge Fleer determined that the state had not presented the specific, articulable facts necessary to justify the stop. Without a lawful basis for the detention, the resulting evidence was inadmissible, and therefore no probable cause existed to support the arrest.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wonder if I'm wrong on
Is that C or an S?
the C judge.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
My concern is, if you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people, that are the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged act.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
Can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough to
Dude,
bring trouble.
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time.
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as is pled is that is pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. And we have to
No,
decide.
he's in custody, you know, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, you know, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond, you know?
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, you know, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, you know? Okay, all right, for sure.
Let us know in the comments if there's a case or courtroom moment you'd like us to cover next. Thank you for watching, and don't forget to subscribe and share to help build a more informed society.